Management of International Financial Services, Module 3, the Employment Contract. In this section, we will focus on the employment contract, and in doing so, we'll examine different types of contracts and suspensions, as well as collective agreements and temporary employment companies. The labor contract. The employment contract. An employment contract is an agreement between an employer and an employee by which the latter is contracted to perform certain services at the behest of the employer in exchange for economic compensation. In layman's terms, it is an employment relationship. This employment relationship is indirectly defined by Article 1 of the Workers' Statutes as workers who voluntarily provide their services in the form of employment within a sphere of an organization and managed by another body, either physical or legal, called an employer or an entrepreneur. Thus, they have the capacity to contract capable businessmen who are of age and legal persons in the form of mercantile companies, associations, corporations, etc. With regard to the employees, otherwise known as workers, they are physical beings over 16 years of old age and fit to work, as are deemed by their parents or guardians, or until they're 18 years of age. Those workers between 16 and 18 are subject to some limitations and cannot perform nocturnal, harmful, arduous, or dangerous work, nor work overtime hours. After having defined an employment contract, we discuss its characteristics. The employment contract is bilateral, with the employer on the one side and the employee on the other. It is consensual, as there is an agreement between both parties. It is also a voluntary relationship, as it was an agreement chosen by both parties. Employment signifies that both employer and employee assume a number of obligations. It is a gainful relationship, that is to say, work tasks and work duties are performed in exchange for payments. The employer has the power of organization and management, as he or she is who directs the employees that they are in charge of. It's a personal relationship because the hiring process was completed as such, and implies that another cannot just assume the role of employee. The following is a description of all individuals who establish an employment contract: people over 18 years of age, people under 18 who are emancipated by reasons of marriage, legal ruling, etc., and people over 16 of age with prior authorization from parents or legal guardians, foreign persons over 16 years of age who have prior administrative authorization to work in the current legislation. It is important to note that children under 16 cannot work, aside from those who are considered artists. As we have seen, all labor relationships involve two parties, the worker and the employer. Thus, it is important to know the legal rights and obligations of both parties. The rights of the employer are management power, which can be exercised directly or via delegation, and disciplinary authority, which implies the possibility of imposing sanctions following breaches of orders or of the contract. The following are the duties and obligations of the employer as derived from workers' rights: free choice of profession or trade, free unionization, collective negotiation, ability to adopt measures in the case of conflict or strike, right of assembly, information, consultation, and participation in the company, effective occupancy in the labor relationship, promotion of professional training in the workplace, non-discrimination for employment or once employed, for reasons of sex, marital status, age, where within the limits established by law, race, social status, religious or political beliefs, sexual orientation, union membership, language, and physical, mental, or sensory handicaps, except for those recruited in inaptitude for the employment in question. Physical integrity and an adequate safety and hygiene policy in the workplace, respect for their privacy and due consideration for their dignity, timely conception of payments, individual exercise of actions arising from the employment contract, all other rights resulting from the contract. The following are considered the worker's duties: to meet the obligations of his or her job in a faithful and diligent manner, to observe and comply with health and safety measures adopted by the employer, to follow orders and instructions issued by the employer, to not oppose the activities of the company, to help improve productivity, all other things as laid out in the work contract. Following are situations in which an employee can request exemptions to the above-mentioned stipulations: lack of capacity on the part of the individual giving orders, an order that is contrary to criminal law or to the Constitution, a violation of professional rules, or one causing professional disrepute, one that poses a risk to the health and/or integrity of the worker. Types of contract. As mentioned, the employment contract is an agreement either of written or spoken nature as manifested by two involved parties. In order to understand some general differences in different contracts, we will differentiate between indefinite and temporary contracts. In reference to permanent contracts, we will include the following: ordinary indefinite contracts, disabled worker contracts. Temporary contracts can be causative for worker services, temporary due to the production circumstances of an interim nature or of a relief nature, training in practice or educational training. Before turning to the main characteristics of the most common types of contracts, let us further examine their form and content. Generally, labor contracts are made in writing, but certain exceptions are made orally. However, for legal certainty, it is highly recommended that the contract is drafted and written, as it clarifies the terms and helps clear up any doubts further down the line. An employment contract with a duration longer than 4 weeks must be made in writing and must include the following conditions: the identity of the parties, the start and date and duration of the employment, registered address of the employee and workplace, professional category, initial base salary and salary supplements, working day, duration and distribution, holiday, prior notice, trial period, collective agreement, if applicable, date, signature of both parties. Now let us examine the different types of contracts and their main features. They can be divided into main types: indefinite contracts, temporary contracts, learning and apprenticeship contracts, training contracts. Prior to further examination, it should be noticed that we will only examine the main features of these 4 general types, and more specific information can be found in the annexes. Indefinite contracts are those that are drafted without establishing any time limits in regard to the duration. The workday may be full-time, part-time, or designated to completion of fixed services or tasks. The rules governing these types of contracts are royal legislations, which approving a revised text of the law of the workers' statutes, and the royal decrees on the communication of the content of employment contacts, the inclusion of public employment services, and the use of electronic means. Indefinite or open-ended contracts include the following types: ordinary indefinite contracts, indefinite contract of person with disabilities, indefinite contract of person with disabilities in special employment centers, indefinite contract of person with disabilities in labor enclaves, indefinite contracts that support entrepreneurs, indefinite contracts of a young person supporting micro or self-employed entrepreneurs, indefinite contracts for new youth workers entrepreneurship projects, indefinite contracts with training and educatory relationships for workers in situations of social exclusion, for workers who are accredited victims of gender violence, for workers of domestic violence or terrorism or human trafficking. Indefinite contracts for workers of social exclusion from or integration companies. Indefinite contract for family members of a self-employed worker. Indefinite contract for workers over 52 years old that are beneficiaries of unemployment subsidies. Also for workers from a temporary employment agency with a contract for first-time employment, training contracts or apprenticeship contracts. Indefinite contract for household services. Indefinite contract for prisoners in correctional institutes. Indefinite contract for group of workers, and indefinite contract for senior management. Just a quick review of international financial services, the indefinite contracts. These are governed by these various royal decrees, and there's quite a few different ones, so we need to just look at them quickly again. Ordinary, indefinite, persons with disabilities, special employment centers, etc. There's quite a few. The entrepreneurs, the young persons, new youth enterprises, all these sorts of things. Oh, let's make it a little bigger so you can see a bit better. Yes, that would be good too. Right, good. Anyway, there's quite a few. There's special consideration for young persons, etc., and or even a training, very similar to that work training program that they had many years ago in England. And there's special arrangements for victims of gender violence, domestic violence, human trafficking. Quite a few for workers of social exclusion for integration companies. Contract for family members of self-employed workers. Interesting, here's a number. This might be important. 52 years old. Beneficiaries of unemployment subsidies. Household services. Contracts for prisoners. And contracts for group work. Indefinite contracts for senior management. Now, those called indefinite contracts. Now we come to temporary. And as suggested, these temporaries are the ones to establish employment for a fixed period of time. And it may either be full or part-time, but a fixed period of time. And these are governed by these various statutes and laws. Here are some different kinds of temporary contracts as opposed to indefinite. Let's go back first. Let's just clarify the temporaries are the ones for a fixed period of time. Let's quickly go back and look at what indefinite. Indefinites are ones without established time limits, as you may notice from this, but temporary contracts are the ones where it says a name, it says something along those lines. And again, you have the various areas, Replace workers for training benefits. Yes, so that would be ones where maybe the actual worker is off on a training program, so this worker is doing that. Foster care during period of maternity. Yeah, this is quite common in Canada, that one, the maternity leaves. So if you're the person replacing them, then you have a temporary contract. And you're replacing temporary disabled, all sorts of different ones. It's almost the same things. It's the people who are, for a fixed period of time, replacing those other ones we've just mentioned briefly. Almost the same sort of thing. Training and educational, you're filling in for someone who's off of training. Social workers, and all sorts of things. Let's keep going down. Spanish Science Department, Technology, this is interesting. Minors and youth in juvenile detention centers, okay. And for group work, okay. Training and apprenticeship. Now we come to training and apprenticeship. These are very big in Germany, called Ausbildung. But here the contracts are seen as instruments to promote employment by way of paying young people through training as well as economic means. And here are the legislation that govern these sorts of things, the royal decrees, the provisions of the law, and the orders and decrees. National system of youth guarantees. Right, now these types of contracts, here they are. Temporary contracts for training and apprenticeship. These apprenticeships we're talking, remember, contracts for training and apprenticeships in employment and training programs, temporary contracts for training and apprenticeship for persons with disabilities. Now we come to training agreements. This type of contract aims to provide an opportunity for workers to receive adequate employment opportunities based on their level of education and training, and is usually applicable to persons in possession of This contract is usually applicable to persons in possession of a university degree, or those who have a higher level of vocational training, or those who are the recognized equivalent. And here are the regulatory laws that go with these. Worker statutes, urgent members, reform in the labor market, etc., etc. In relationship to training contract, it is good to consider the following. Training contract held by the ETT. Let's see if we get that out of the way. It's blocking us, so we touch. Yeah, okay, there we go. What in the world is ETT? Let's see if we can go back and find anything about that. Let's just do that right now. While we're still, I think this is actually a search thingy. No, that's a Zoom thingy, okay. Yeah, the search engines aren't quite so good with Google as they are with Edge. Probably should have gone in there, but we'll know that for next time. ETT, okay. Anyway, on we go. And temporary contracts for training apprenticeships held for persons with disabilities, training agreements. Here we go. These are the regulatory laws. Temporary training held by the ETT, temporary training contracts for persons with disabilities. If you would like to learn more about contracts and their implications, refer to the annex. Now we have modifications, suspensions, interruptions, and terminations of employment contracts. After examining all these different programs, it is now time to understand the situation that may lead to a modification, suspension, interruption, or termination. Labor contract modification can be modified due to some, here are some reasons for why we changing a contract. Well, geographic mobility. This refers to a change in the workforce place environment that may result in displacement and thus a change in residence for the worker. In principle, unless otherwise agreed upon, when a worker begins his activity, it is presumed that it will continue unabated at that place. However, depending on the circumstance of the company, it may decide to change the workplace, which would result in the need to change his or her place of residence. This kind of thing is known as an ius variandi, or the right of the employer to change or modify the workplace. And we can distinguish types of change as either temporary or permanent. Transfer implies a permanent change, and displacement implies a temporary one. Different words: transfer, displacement. Keep those two different words in mind. Transfers means a permanent change to the new location. In order to move a worker from one place to another, some form of justification is required. It can be economic, technical, production-based, or organizational. And here are some examples. Here are the exemptions, rather, not the examples. Work contracts in which an employee has been hired to provide services in mobile centers, and those in which the nature of the work implies a geographic mobility. Right. Transfer as a disciplinary sanction or a voluntary agreement between the employee or employer. Maybe a way to get rid of a troublesome worker or move a troublesome worker. And within the realm of transfers, remember, transfers are permanent. Care must be taken to differentiate between individual or collective. Individuals, rather than the union thingy, transfers that within a period of 90 days affect, and they specify less than 10 people. If the workforce is 100, less than 10% if it's between 100 and 300, and fewer than 30 workers if the workforce exceeds 300. Now, a collective transfer is a transfer that affects the entire workplace of a company and has a workforce of over 5 employees or at least more than 10% of them. This is a collective. By law, the company must submit to the worker and their legal representatives notice of any pending transfers within a period of no less than 30 days before the scheduled transfer. Faced with this notice, the employee E has several options. Here are the options. They can accept it and a compensation they're entitled to, and for their dependents, they can terminate and receive compensation according to 20 days of salary per year worked. 20 days per year worked. That would be very interesting. If a person's worked someplace at 30 for 30 years, guess what? That's 600 days. That's getting pretty close to bang on 2 years of salary. Anyway, a challenge to the legal admissibility of the transfer. That also could be another possibility, saying that you're violating the workers' rights, etc., etc. Now, this option is only available if within the contract the possibility of a transfer was not agreed on. So, if you're the employer and this is a possibility, you better put it in the transfer. You better put it in the contract that there might be a transfer. Otherwise, you could be stuck with this. Now, let's contrast this with a displacement. A displacement is a temporary workplace. It could mean the bridge is out, or the roof fell off, was ripped off by a hurricane of the main place where this factory is, but it's only temporary until it gets fixed. By the way, the definition of displacement is can't be more than 12 months in a given 3-year period. And if it exceeds that, all of a sudden it's considered to be a transfer. It's affected by the rules of transfer. And as in the case of transfer, the company must be able to justify the reasons. I think your roof torn off by a tornado might be one of those. A displaced worker is entitled to the following. In addition to a salary, they are entitled to reimbursement for their travel costs. They are entitled to 4 working days in their original place of residence for every 3 months of displacement. This includes travel days. Yeah. 4 extra days every 3 months, yeah? Yeah, so if this is like for a whole year, and it's supposed to be temporary, right? You're entitled to travel costs, and let's suppose it was for a year, you would get 16 extra days of working days over a year, like 3 months, 4, right? And depending on the duration of the displacement, the employee should notify the worker of the final decision, and you've got to give some notice. So if the displacement is equal to or less than 3 months, 2 or 3 business days, and if the replacement is more, a business of it's going to be for like a year or something. Remember, only up to a year. You need to get 5 working days. Now we come to functional mobility. Functional mobility refers to the organizational and managerial delegation of different work to employees, perhaps delegating tasks to workers that they were not initially hired to. However, it is important to note that these decisions will be made according to the academic and vocational qualifications needed to perform the said task. When the contract is drafted, as has been discussed, every worker is contained within a pre-established professional category. This category implies dedication to a specific function or set of functions. Thus, the need of functional mobility is predicted on technical or organizational change that justify this mobility. If faced with this type of mobility, it is important to note that the worker must be granted the following rights: respect and dignity for training and career advancement. They should receive a salary that reflects the new activities, unless the new functions are of a lower pay grade than the ones that before. In other words, if they take more responsibility, they should be paid more. They must have guarantees against dismissal for objective reasons, such as functional mobility occurs, such as when functional mobility occurs when the company is not able to dismiss the worker under the guise of ineptitude or inability to adapt. Yeah, in those cases in which the performance of higher functions is more than 6 months of a year, or more than 8 months for 2 years, the worker must be allowed to request a promotion. Good on ya. Okay, lots of work protections here. Substantial change in the working conditions, and as suggested, the contractual modification concerns a change in working conditions that was previously agreed on. As before, the company will be required to present economic, technical, organizational, or production-based justification for these modifications. These modifications may affect the number of work days, schedule and allocation of working time, planning of worksheets, pay systems and salary amounts, systems of work or performance. In regard to these amendments, it's worth mentioning that they are regulated by a certain article called the Workers' Statute, Article 41, and it is understood that there are various cases that give rise to substantial modifications. They must be modifications to help with the organization. They may help the negative development or perception of the company, and a positive one to improve the company's organization and competitiveness. Substantial changes to working conditions can be an individual or collective, whereas the first is specified to the individual, the latter can be established by collective agreement through the company's decision that yields collective effects. Modifications considered individual in character will affect less than the following proportion of the students for a 90-day period. Here they are, 10 workers, of 100, 10%, you get the idea of 300, 30 workers, yeah, they could be called like individual. Okay, when the company makes substantial changes in the working conditions in a successive period of 90 days, fewer than thresholds established by collective modifications without new causes to justify such actions in order to avoid the maneuver from being defined as modifications of a collective nature, then modifications are considered made in circumvention of the law and shall be declared fraudulent, null, or void. Yeah, this is kind of important. If it's almost like we might call it constructive dismissal, or I kind of try to weave around all those extra benefits that a worker would get. So this is an attempt to protect the worker. Modifications considered collective in character will affect at least the following, and now you get it: more than 10 workers in a company that's under that, so that's more than 10%. 10%, yeah. Workers 30, yeah. Workers affected by substantial modifications of the workplace are able to terminate their contract and receive the equivalent of 20 days of wages per year. If less than a fiscal year, will be calculated and paid as if it were monthly and a maximum of 9 installments. Now, let us discuss substantial modifications in working conditions as understood and conditions of collective agreements establish the parameters that to modify the terms of collective agreements as regulated by the workers' statute. When the amendment concerns changing in the working conditions, it is important that an agreement is made between both parties before any changes are made. Both sector and the company agreement that are mentioned in the workers' statutes can be changed in the agreement case of the agreement being made. If they are sector-focused collective agreements, the agreement will be undertaken in the joint committee of the sector. And if agreement is not reached, mediation procedures will be sought through a further collective agreement or professional agreement. In this case of a stalled mediation, the agreement committee can submit a binding arbitration to supersede the agreement process. The binding arbitration will have the same efficacy as the agreements of the consultation that would have happened in the consultation. Management of International Financial Services, Part 3. Modifications may only affect the schedule and allocation of working time, pay schedule, planning of work shifts, systems of work, and performance. Just to remind you of what we're doing, since this is, after all, Part 3. These are defined as substantial changes in the working condition. And if they're collective character, they have to affect more than 10% of the population of the working group. And here we are on this one. So modifications for these collective agreements can only affect the pay system, planning of work shifts, system of work performance. Suspension of the employment contract. Suspension of the employment contract is a period which the work and payment stops or pauses without implying termination of the contract. This form of suspension is regulated by Article 47 of the revised law of the Law of Workers' Statutes as approved by the Royal Legislative Decree. The employment contract may be suspended for the following reasons: by mutual agreement, for recorded causes invalidated in the contract, maternity or paternity, risk during pregnancy, adoption, or foster care, children under 6, military service, of course, public service, office, or representation pending the result of a judicial decision, a suspension without pay because of a disciplinary action, temporary powers beyond the control, otherwise known as force majeure, and you may recall this could be like a tornado that tore the roof off of, and so on and so forth. Anyway, economic, technical, organizational, production-oriented reason, active status, exercising the right to strike, legal closure of the company, decision by workers forced to leave their jobs as a result of being victims of gender violence. I already mentioned the suspension of the employment contract exonerates the reciprocal employee-employer relationship. It is also important to note that in the case of the temporary contract, suspension does not necessarily result in its expansion. The suspension of the employment contract may be undertaken for a variety of reasons. Leave of absence, regulated by Article 46, states the leave may be voluntary or forced. Compulsory leave of absence are those that occur as a product of appointment or election of the public office, which prevents the person in question from being at their workplace. And in this case, the worker is entitled to retain his job in his senior seniority status, continues computing. That is to say, continues to go. Voluntary leave of absence, in contrast, this was a compulsory leave of absence. Okay, this is a voluntary result of a voluntary decision made by the employee to temporarily suspend, and the aforementioned law retains a priority for the employee in the case if he decides to return, but his readmission is not guaranteed. In addition, if the employee is readmitted to the company, it may be in another workplace with a new schedule, new contractual conditions. Now, if we have suspension of work for economic, technical, organizational, production, or reasons of force majeure, faced with causes such as this, it means to justify them. The employer may suspend the employment contract of the employee, and thus further examine some of the motives or contractual suspension. Economic cause refers to cases stemming out of the negative economic consequences, and may be due to occurring or anticipated loss or persistent decline in income. The technical causes occur alongside changes in production technology. Organizational causes refers to organizational changes in the company's system, staffing, and production. Production causes refers to fluctuations of availability and demand of products or services that the company offers. This type of suspension is regulated by Article 47, and suspension with guaranteed job safety refers to employment suspension wherein the job is reserved for the employee upon the return. With that being said, after the suspension period, the work will be able to return to his or her prime employment with the same conditions as it were in his contract before, and the conditions of this type of suspension are established by Article 48. The suspension of employment contract due to paternity or maternity refers to the worker's right to suspend his or her contract due to childbirth, adoption, or foster care, also regulated by Article 48. Now we come to the interruption of a labor contract. Interruptions are of a type of suspension, but usually have a shorter duration. Further, they do not produce a termination of the contract and do not affect the payment of wages. Therefore, if an interpretation is properly notified to superiors, the employee continues to be paid throughout the duration. And interruptions can be as follows: by the will of the worker, personal circumstances, 15 calendar days after marriage, 2 or 4 days for childbirth, fulfillment of public duties, time necessary. I imagine that might mean jury duty. Fulfillment of trade union representations or functions, time necessary. The exercise of educational rights, the circumstances related to labor conditions, changing of moving residence, 1 day permit for moving, and other causes, reasons attributable to the employer, and interruptions due to a force majeure. Now we come to the termination of the employment contract. This entails termination of the employment relationship between the company and the worker. This termination can be due to a number of causes or motivations, such as mutual agreement between the parties, causes recorded and validated in the contract, expiration of the agreed upon time and completion of the worker's service contract, resignation of the worker, withdrawal of the contract due to workplace transfer, withdrawal of the contract for modifications of the workday schedule, shifts, or wages that may impair the worker. By voluntary will of the worker in response to substantial modifications of the workplace conditions, especially those carried out in opposition to Article 41 of the Workers' Statute, which affects the dignity of the worker. By the voluntary will of the worker in response to serious failures on the part of the employer, or the death of the worker, of course, retirement of the employee, death, retirement, or disability of the employer, termination of the legal entity of the employer, dismissals due to objective causes, collective dismissal due to an economic, technical, organizational, or production process pressures, uncontrollable forces, which are force majeure confirmed by the labor authority, disciplinary dismissal deemed inadmissible, objective dismissal deemed inadmissible. At the time of notifying the termination of the contract, the company must attach a settlement notice with all of the proposed payouts. When signing the final severance settlement, the employee is entitled to request the presence of legal representatives. If the company prevents the presence of the legal representative, an employee may include it in the receipt itself for the appropriate purposes. Now let us examine some of the reasons that lead to termination of employment contracts. And while the following are considered just causes for an employee to request a termination of his or her contract: substantial modification of the workplace conditions that negatively affect the professional training or the affect the worker's dignity, a non-payment or delays in payment, any other situation that constitutes a serious breach of the company's obligation, except in the cases of force majeure. In addition, is the refusal to reinstate the worker in his or her previous working condition as provided by Articles 40 and 41 of the current law when court ruling declares them unjustified. In the above-mentioned cases, the employee is entitled to compensation for unfair dismissal. Now we come to termination for objective reasons. These must be certain conditions that require the termination of the employment contract on behalf of the employer. Employee contract may be terminated by the employer for the following reasons: the unsuitability or inaptitude proceed after the employee has begun working, inaptitude recognized prior to the completion of the probationary work period and cannot be used as a justification after the probationary work period has ended. Where work is unable to adopt the technical changes in the workplace within a 2-month period, if such changes are recognized as reasonable, the employer will be asked to provide training. Oh yes, the employer will be asked to provide training courses to assist the worker in order to improve their competency with the new technology. The time designated for these training programs are considered an effective use of working time. During this course of work, the worker will be paid its normal working wage when there is an objectively accredited need to amortize jobs for any of the reasons set forth in Article 51.1 of this law and in lower number than that established therein. To this end, the employer will attribute the decision for termination to economic, technical, organizational, or production-oriented causes. The workers' representatives will have a permanent priority within the company during this supposed separation. The cases of intermittent, albeit justified, workplace absences that affect at least 20% of the workdays in 2 consecutive months or 25% of the workdays for 4 consecutive months within a 12-month period. Absences due to the legal strike, trade union activities, a worker injury, or a number of other causes will not be counted. So absences due to a legal strike, trade union activities, a worker injury, and a number of other causes will not be counted. Termination for disciplinary reasons. This refers to the worker's termination by the company's decision due to the worker's serious breach of obligations. The legal grounds for dismissal are the repeated and unexcused absence or a punctuality problem, disobedience or lack of discipline, verbal or physical abuse towards the employer, co-workers, or the family members, abuse of trust or breach of good faith as contractually obligated, continuous decrease in workplace performance as compared to the standards established in either the contract or the collective agreement. Drunkenness or drug addiction, harassment of co-workers or employees on the basis of race, ethnicity, religion, disability, age, or sexual orientation. Termination by collective dismissal. Now, collective dismissal is understood to as being a problem rooted in economic, technological, organizational, production-oriented causes that necessitate the mass layoff of workers to improve the company's situation. In order to be considered a collective dismissal, the following proportion of workers need to be affected in a period of 90 days. 10 workers in case of under 100, 10% of the workers, 100 to 300, 30 workers if it exceeds 300. If the company purposefully undertakes the layoffs in a period longer than 90 days so as to avoid legal recognition as collective dismissal, it is considered legal fraud and is punishable by law. It is also considered collective dismissal if the termination affects the entire workforce when the number of workers is over 5, produced as a result of the total cessation of business. Collective agreements. Continuing to the theme of contracts, the following sections will be dedicated to understanding collective agreement. And by way of definition, a collective agreement is an agreement pertaining to a specific labor sector that is signed by employees and workers' representatives and aims to establish a standard of productivity, workplace conditions, and worker obligation. Thus, it requires all employees and employers in a certain sector to comply with prior agreed upon rules and stipulations regarding labor. This agreement regulates a variety of aspects that affect the workers' relationship, such as wages, workers' hours, breaks, vacations, work condition, union representation, except that the main labor topics affected or regulated by collective agreements are as follows: economic wages, indirect wages, overtime pay, labor, working days, weekly or yearly working hours, as well as vacation, professional categories, contract duration, performance standards, union, work councils, personnel representatives, negotiation rules, conditions of employment, criteria for determining method, personnel, and material of private prevention services, relationship between workers' representative organizations and the employer's business association, assistance, voluntary improvements to Social Security, career advancement measures, work conditions and productivity, measures to promote equal treatment and equal opportunity for men and women in the workplace. It is important to note that the conditions set out in the collective agreement are the minimum conditions under the Labor Relations Act as are regulated. That is to say, they can be improved, but never worsened. In case where there is no collective agreement, working conditions are governed by statutory and regulatory minimum requirements established by the workers' statutes. In regard to the classification of collective agreements, two types can be distinguished: company agreements and sectoral agreements. Here are some company agreements. Company agreements, these are the type of, which are agreements it's company specific. The agreement regulates labor and services rendered, economic compensation, labor relations, etc. for all the employees of the company, regardless of the professional category. Whenever a company has a collective agreement, it is binding for all parties. It is unaffected by sector-specific agreements unless otherwise agreed upon. Now let us talk about sectoral agreements. Within this type of agreement, the working conditions for an entire business sector, such as the automotive or hospitality section, are negotiated. Their application is mandatory for all companies in each respective sector, except in the case of company-specific agreements as mentioned above. Sectoral agreement can establish labor relations on a national level within autonomous communities or on a provincial level. All the content contained within the collective agreement is public and legally required to be published as the official Spanish Gazette. As such, national agreements are available on the website of the BOE, and CCAA agreements are found on the respective autonomous community websites. In order to further understand specific regulations of collective agreement, refer to the annex. Now we come to temporary employment agencies. That was the ETT. To conclude our discussion of contracts, we will discuss temporary employment agencies, ETT. This type of company contracts out employment opportunities to temporary workers, and that is to say, the ETT seeks employees to work temporarily for other companies. This process involves three parties, resulting in a triangular relationship between the company seeking the employment, the ETT, and the worker. This triangle results in two types of contracts. Contracts between ETT and the company seeking temporary workers, and between ETT and the temporary worker. The legislation that should be consulted regarding this type of contract is given, which is temporary employment companies are regulated. In addition, the following will be of interest. Law 3/30/2015. In temporary employment agencies, they may also act as a placement agency when they meet the requirements of the employment law. Furthermore, they may develop and implement professional qualification training programs in accordance with the regulations. Here now are the regulations, the royal decrees, the laws, the royal decrees, and there's quite a few of them actually. Oh, let's find out what they actually do then. Minimum safety standards, fixed term contracts. Okay, let's keep going down here. A revised text for the workers' statutes concerning the displacement of workers within the framework of transnational services. On urgent matters to reform the labor market to increase employment and improve quality, and also on urgent matters to reform the labor market. On urgent matters to reform the labor market. The contract that arises from this temporary relationship is called a service contract, which is established between the ETT and the company by which the worker will be hired to provide services. As such, it is an agreement that does not explicitly involve the worker, but rather of the temporary economic nature between the two companies. Also, a contract between ETT and the temporary worker will be established. It's important to note that these two contracts do not necessarily have the same duration. However, in cases where the contract with the ETT has ended and the worker continues providing services for the company, it shall be considered an indefinite employment relationship between the two. Some examples wherein a company is not allowed to request temporary workers from the agency is to replace striking workers, to carry out work that is especially hazardous and might have a negative impact on the health and safety of the worker, such as cleaning up the Fukushima nuclear plant. When in the 12-month period immediately before the contract, the company has depreciated the jobs that have intended to cover in an unfair dismissal or through causes anticipated in the articles, except in cases of force majeure, or to lend workers out to other temporary employment. It's very important that the company requesting workers informs the worker's representative upon each job made available, such as the reason for deployment, within 10 days after the job's commencement. During the same time period, each available worker should be given a basic copy of the work employment or service contract, which should have been approved by the ETT. Such contracts must be finalized in writing. The ETT should notify the Public Office of Employment of its content in the terms established and required by regulation within 10 days following the commencement of employment. And in between the ETT, or shall we call it the ETT, the temporary workers, there are two types of employment relationships. Employment relationships between the ETT and the ETT workers. If the workers' actives performed by the workers will be exclusive to the ETT, the standard rule regarding work contracts will be applied. As these workers will be providing the services within the structure of the ETT, they will be managed solely by the ETT. These cases will be regulated by Articles 13 and 14. If not, then Social Security legislation will apply. Now we have employees' relationship between the ETT and the temporary workers that will be subcontracted. The workers that provide their temporary services to companies may be subcontracted on either a permanent or temporary basis. These contracts must comply with certain formal requirements. It is important to note that the permanent contracts are infrequent, as ETT tends to focus on temporary contacts. Thus, permanent contracts are usually established following legal claims by workers against the ETT for fraudulent contract. In addition, the ETTs may offer a work contract in training and apprenticeship for the contracted worker, so as to prepare them for work that they will be subcontracted into other companies. The ETT can offer the temporary worker an employment contract that hires out their services to various companies, providing the signed contract allows these contracts must correspond with paragraph 1 of Article 15 of the Workers' Statute. Now, as previously discussed, the worker signs a contract with ETT, and as such, ETT needs to meet the following labor obligations. It is the responsibility of the ETT to ensure that the temporary workers meet all of the salary and SS Social Security obligations. All ETT should allocate on an annual basis 1% of the total payroll to the training of temporary workers subcontracted by companies, notwithstanding the legal obligation to pay for professional training. It is the responsibility of the ETT to ensure that the worker, prior to starting work, has the theoretical and practical training necessary to prevent occupational hazards. In doing so, they should take into account their qualifications and professional experience, as well as the risks that they will be exposed to. In those cases, the workers do not have the proper training, the ETT should provide it. And no ETT may request payment from workers for recruitment, training, or employment. Disciplinary power always rests with the ETT. The responsibilities and obligations of the company hiring workers through the ETT include the following. When the worker starts employment with a company, the management and control of the worker's activities will be passed on to that company. However, in the case where the worker fails to come through or some aspect of his contract, the company will notify ETT of it, which will be responsible for determining the appropriate action and sanctions, informing workers about the risks arising from the work activities as well as the preventive measures needed to avoid them. The responsibility for the health and safety of the workers in the workplace, responsibility for the workers' wages and the Social Security obligations for the entire duration of the temporary contract. Also, obligations to inform the workers lent by the ETT of vacancies so that they can seek permanent employment within that company when opportunities arise. The workers have the following rights. The worker, whenever he or she perceives any irregularity, may submit complaints in regard to working conditions. The right to utilize public or communal transport or other opportunities offered by the company for the duration of their worker activities with said company. And the workers are entitled to regular health monitoring by the ETT, taking into account the characteristics of the job to be performed. Now we come to the International Labour Organization, the ILO. To conclude our discussion on the topic of recruitment, we will devote this section to the International Labor Organization. The ILO is a special agency of the United Nations, which is responsible for governing many aspects of employment and labor relations. Since its establishment on April 11th of 1919, the ILO has a tripartite government composed of administrative representatives, employees, employers, with a grand total of 187 member states. Their main objectives are to set labor standards and develop policies and programs that promote decent work of all workers, men and women too. Anyway, it's a special organization which is responsible for governing. Okay, let's make sure we get going here. Okay, boom. A special organization, many aspects of employment or labor relations since its establishment on April 11th, 1919. The ILO has a tripartite government composed of yes, we just read that, set labor standards and develop policies and programs to promote decent work for all men and women, to promote social justice and recognize core labor standards, to create employment opportunities to improve working conditions worldwide. Thus, the main mechanisms of the ILO are the establishment and supervision of the international labor standards, providing technical assistance and the research and dissemination of information. Their fields of activity include the following: promotion of respect for basic labor principles, eradication of child labor, supervision of labor relations and compliance with agreements, development of technical cooperation programs, labor migration, analysis of social dimensions of globalization. In regards to the functioning of the ILO, it operates through three main bodies. The International Labor Conference. The body meets once a year to establish international labor standards and to define the general policies of the ILO. In addition, it is also a forum for discussion of key social and labor issues. The Board of Directors, this is the exclusive body of the ILO, and meets in Geneva 3 times a year. Their task is to making decisions in regard to the ILO policies, the establishment of the programs and budget, which is then submitted to the conference for adoption. And the International Labor Office, this is the permanent secretary of the ILO and is responsible for all the ILO activities carried out under the supervision of the governing bodies and management of the general director. The work carried out of the bodies of the ILO gives rise to what is called the International Labor Standards. These are the legal instruments that act to reinforce the principles and fundamental rights of work, regulate all other aspects of the working world. It is important to note that these rules take the form of agreements and recommendations. The agreements are recognized as legally binding on the international level. They can be ratified by member states of the ILO, and in most cases, they establish the basic principles that all member states should implement. Recommendations, on the other hand, serve only as non-binding guidelines. Nonetheless, the ILO also adopts other legal instruments, such as the declaration and resolutions that contain official declarations that act to reaffirm the importance of the principles and values submitted by the tripartite. This text will not go into great detail about the international labor standards, but a case study that can be found in the annex will give further details. As mentioned, the ILO strives to achieve optimal labor conditions on a worldwide level, and here are some of the important programs and issues: child labor, decent work, disability, ethical recruitment, promotion of employment, economics, equality and discrimination, freedom to belong to a union, further future of employment, and sustainable jobs. And these are only a few of the many themes and programs that the ILO focuses on. In the annex, you will find links to learn more about the programs.